Hello, everyone. Welcome to Court with Krissy. You all know Judge Dad.
Settle down!
Well, here on Court with Krissy, he's now going to be called Detroit Judge Dad. Why? Because Judge Cooney, he's our up north Judge Dad. He still lays down the law, but sometimes he might use a little leave it to Beaver lingo while doing it.
Gee whiz.
I hope you like it. Court with Krissy is now in session.
Ms. Kreinbrink, just let me know when you're ready.
You're ready, Your Honor.
Okay, then, Mr. Monroe, if you want to come on up. This is People versus Drew Monroe, file 2083 of 2024. Ms. Kreinbrink is here on behalf of the defendant and Mr. Olson for the people. This is the date for sentencing on defendant's conviction of domestic violence second offense. And Ms. Kreinbrink, have you had an opportunity to review the pre-sentence report with your client? Is it accurate and complete?
Your Honor, we did have a chance to review the report. We do have a couple minor corrections for the court to consider at this time.
Okay.
The first would be the amount of credit that Mr. Monroe has, or I guess the time that he's served thus far. He began his term incarceration on the morning of November 27th, which was approximately 15 days ago, but with good time, I believe that would add an extra 2 weeks.
I have credit for time served is 2 days, and he had 2 as of 11/26. So let's see, 20. That's 4 days in November, and today is the 12th. So I have 18 days altogether credit for time served. Does that sound right?
Yes, Your Honor.
Okay, and the jail will do the good time
Thank you.
calculation.
Your Honor, the other correction we would have is that the report indicates that my client and Ms. Powell have a child in common. Actually, that child was from a prior relationship. They do not have a child in common with one another.
Okay, thank you.
And then the final correction, Your Honor, is that we would ask the court respectfully to consider only the incident that happened on May 4th. The report indicates a prior altercation between my client and Ms. Powell that happened on May 3rd. But actually the May 4th incident with the sunglasses being knocked off served as the factual basis for my client's plea. So respectfully, we just ask the court to consider only that incident.
Okay, thank you.
And apart from that, Your Honor, we would have no other corrections to the pre-sentence investigation report. And we've also found that the substance use assessment is also accurate.
All right. Mr. Olson, do you have any concerns about the report or the evaluation?
Judge, I don't have any concerns about the evaluation. In response to Ms. Kreinbrink's comments about not considering the information about the night before, it is in the defendant's description of the offense. I would just note that's his statements to the probation officer, and it does conflict with what was reported by the victim to the deputy at the time. It's just I think it's just the court can consider it for acceptance of responsibility purposes. Certainly he pled to the incident involving the sunglasses, which was the basis of his plea, but it is a statement, and we would think it's irrelevant to consideration of his acceptance of responsibility in this case.
All right. Well, this court considers all relevant evidence that is supported by at least a preponderance of the evidence. So with that, Ms. Kreinbrink, allocution.
Thank you, Your Honor. Your Honor, Mr. Monroe stands before the court today following his guilty plea to the offense of domestic violence second offense. Contrary to what that pre-sentence report indicates, my client has taken responsibility for what occurred in this case. by entering his guilty plea, and certainly is very remorseful for what happened. At the time of the incident, Your Honor, my client and Ms. Powell were in a relationship with one another and were living together. My client admittedly had consumed alcohol the morning of, which led to the sunglasses being knocked off of Ms. Powell's face. Certainly, Mr. Monroe presents with a limited criminal history. He does have a prior conviction for operating while intoxicated, second offense. He was on probation for that offense at the time of this incident. But certainly following this event and from all my communications with Mr. Monroe, consistently he's been a very prompt, respectful, and forthright client. And one of the things that he's been very upfront about is his relationship with alcohol. And I think he has a recognition that alcohol does not serve him in a positive way. And he is currently engaging with outpatient services and counseling to address that relationship. He wants to live and is striving to live a sober lifestyle. Currently in jail, he's living a sober lifestyle. But out of jail as well, Your Honor, he's committed to living a life of sobriety so that he can move forward in a positive direction. He stands before the court in a different situation than many other individuals this court sees. He has full-time employment with Williams Chevrolet. He actually has a position where he trains other individuals. He has the support of his employer, who I believe earnestly wants him to go back to work. He has support of family, of friends, and should he be released back into the public, he has that support system to rely on. And I think since this incident, he has a fuller appreciation of not only living a sober lifestyle, but of taking advantage of the support of those around him, together with the services that he's already been participating with. The pre-sentence investigation report, Your Honor, recommends in this case no probation for Mr. Monroe, but also a, quote, large jail sentence. Our concern in this case is simply that a sentence in this case, while imposing a deterrent effect, would only set Mr. Monroe back. He would likely lose his employment and would no longer be able to take full advantage of the services and again, of his support network that he has to live a sober and positive lifestyle. Even though he is a young man, I think he does have recognition that he's made bad decisions. And in all of my conversations with him, he's indicated that he wants to move forward in a positive direction with his life. He has a family that depends on him. And Ms. Powell is also present in the court today, and I believe would make a statement. But certainly, Your Honor, we would ask the court to consider Mr. Monroe's employment, his commitment to living a crime-free and sober lifestyle moving forward, and his remorse for the actions that bring him before the court today. Thank you.
Thank you. I would like to hear from you, Mr. Monroe. Is there anything you'd like to add?
Yes, I just want to take this time and apologize to the court and everyone involved for my actions and behavior. I made mistakes and decisions I wish I could take back. Wasn't in jail the last 15 days. I've had time to reflect back on life. I've struggled with addiction to alcohol over the years and disease. I realize my drinking is my biggest downfall. I wish to continue my probation and remain sober, so I can continue to do counseling and AA and anger management, so I can get the tools and guidance and knowledge I need and want to make sure I don't come back to this courtroom and make the same decisions. I want to live my life happily with my 2 kids and my fiance. And I'm so hurt knowing I'm going to miss Christmas and my son's birthday, knowing it's going to hurt them. I take responsibility for my actions and accept my punishment. I hope you can have mercy considering my sentence and take it into consideration for my family that relies on me and my income, or they will end up homeless if I'm gone long. And my team and job, for they rely on my guidance and knowledge. If you can find it in your heart to give me a chance, I will exceed and pass all probation requirements and be the leader I can be. I've completed all probation successfully in the past, and I will again. I will not come back to this courtroom if I can have anything to do with it, and that is my promise to you. Thank you, Your Honor.
All right, thank you. Mr. Olson, anything for the people?
Yes, Your Honor. I know Ms. Powell would like to address the court as well.
Okay, would you like to have her do that first? Okay, if you please take a seat over here, Mr. Monroe and Ms. Kreinbrink. And if you could start by stating your name.
Katie Powell.
And Ms. Powell, what else would you like me to know?
Just that my report is false. We had a disagreement that today, and it got out of hand with me filing a false police report. Drew is not the man that I described in that police report. Wearing an individual whatever and has never put his hands on him. Drew is my rock. I am the support system. I do not allow alcohol. Drew will eventually lose his job for a long jail sentence, and I will eventually lose the house as well. I depend on him, he depends on me. That is my friend. That is my soulmate. I ask that the no contact order be dropped. This has been hard for me, my son, our family. Mistakes were made. Things were said. Actions were not done though. I went and talked to the prosecuting attorney's office on Halloween, and that was the last time that I've had contact with them. They did not let me know that Drew had entered a plea. I had to hear from my stepfather when he was called to be told that Drew had done a plea deal and he did not have to come to court. I had to call the prosecuting attorney's office to ask what was going on. I did not talk to either Nikki or Olson's. I talked to whoever answers the phone, and they let me know that I did not have to come to this and that Drew had entered a plea deal. I had more contact with Drew's lawyer than anyone. I just want my family back.
Okay, thank you. Mr. Olson, anything for the people?
Yes, Your Honor. I would note that also before the court is a bond violation for violation of the no contact order. That's why Mr. Monroe is currently in custody. I would respectfully ask the court to follow the recommendations that are outlined in the probation officer's report. I don't believe Mr. Monroe has really truly expressed any appreciative acceptance of responsibility. He's minimized his role throughout this case. One of the things I would note to the court is even since he's been in custody in the no contact order, presumably has still been in place, he's been in contact with Ms. Powell from the jail. I have over approximately 80 phone calls from the time that he was self-surrendered on the bond violation warrant. Without getting into too much detail of those calls.
You mean since November 27th, 80 phone calls?
That's correct, Your Honor. Those phone calls reflect, first of all, Ms. Powell deeply cares for him. There's no doubt about that. But his interaction with her, it's not healthy for her. It's been damaging, I think, to her. It's been what I would call emotional blackmail. One phone call, he He indicated that he would commit suicide if he remained in jail. That's not healthy for Mrs. Powell. That's not conducive to a relationship that the two of them want to have. There's no doubt that they still want to have a relationship together, but it has to be a healthy relationship. His lack of responsibility, the victim blaming that's occurred in this case, his description of what happened between him and Ms. Powell is entirely inconsistent with what Ms. Powell indicated to the deputy when they responded to the house, and it's even inconsistent with her account as well. He's victim blaming, he's blame shifting, and I don't believe an order of probation is beneficial here. It's up to him to seek the proper therapy that he truly needs. I don't believe anger management is going to suffice in this type of a case. And so we would ask the court to follow the recommendations of the probation officer. Thank you.
Right, Ms. Kreinbrink and Mr. Monroe, if you please return to the podium. This is sentencing on the defendant's conviction of domestic violence, second offense. And the facts are, as related in the report, this incident began on May 3rd with the defendant apparently asleep while attending an AA meeting. That's what the victim reported to the police. Why she would report such a thing, I have no idea, except that it happened. It would be so bizarre to make up something like that. The defendant, when the victim woke her up, began screaming at her, calling her dumb ass cunt and dumb ass bitch. He then grabbed and punched her leg and choked her. The victim relates that she began choking him after that. Then on May 4th, there was another disagreement. The defendant kicked the victim away from the car, tried to close the door between her and the inside of the car. The defendant was pushing her, slapped her with his right hand, grabbed her sunglasses, and broke those. The defendant does have a prior domestic violence from 2019 and the drunk driving conviction in 2021, and is currently on probation for drunk driving second offense with this court. There is a substance assessment which unsurprisingly found that the defendant does have a substance use disorder, moderate in nature, and outpatient counseling was recommended, but he's already receiving that counseling as part of his probation in the drunk driving second case. In response, the defendant called, in response to the alleged incident, the defendant said that the victim lied and made things up because she was scared, said that he never intentionally shut the door on her, denied breaking her sunglasses, denied pretty much the whole incident. So probation is for people who take responsibility for their actions and wish for rehabilitation. And so Ms. Traska has appropriately pointed out, as has Mr. Olson, that this seems to be a futile exercise. And so, and when I see in particular you're asleep with an AA meeting on, so you can report that you attended, it's obvious you're not taking that probation seriously either. most concerning is that there was a video that was provided to the probation department showing you with the victim. You were out trick-or-treating. Apparently you got engaged to her during the time that you were that the court had ordered no contact, and you admitted to your probation officer that you had contact with her during the pre-sentence investigation. And what is really unbelievable is that you are now sitting in jail because of the violation of the no contact, and you've been contacting the victim 80 times. Those are recorded calls. So I can't help but find that Ms. Trask is right. The defendant has taken no responsibility for his actions, does not seem to be a good candidate for probation at all, because he consistently violates the no contact order. I would expect that that would just continue if he were placed on probation, and that's not going to happen. I was considering maybe a 6-month sentence, but given the fact 80 calls, you just bought yourself a year in jail. The fine is $100, costs $375, crime victim, $50 judicial system fee. That's it. We'll be in recess.
Here.
All rise.